The last thing Amy Coney Barrett expected that day was the folder in Jasmine Crockett's hands. The folder contained Barrett's own law review articles, writings from the 1990s, from before she became a judge. As Crockett quietly flipped through the pages, Barrett wondered, what is this woman finding in there? But what Crockett had found would completely contradict Barrett's current positions. The Hart Senate office building buzzed with anticipation on that crisp December morning. Room 216, typically reserved for routine oversight hearings, had been transformed into something resembling a constitutional courtroom, complete with additional seating for the unusually large crowd of legal scholars, journalists, and constitutional law students who had gathered to witness what many were calling the most important judicial oversight hearing in a generation. The atmosphere was electric, with the kind of nervous energy that preceded historic moments. C-SPAN had dispatched 3 cameras instead of their usual 2. Major news networks had sent their top legal correspondents. Even the normally blasé Capitol Hill press corps seemed energized by the potential for drama. Justice Amy Coney Barrett sat at the witness table with the composed dignity that had defined her tenure on the Supreme Court. At 52, she embodied the conservative legal movement's ideal of judicial restraint and constitutional originalism. Her confirmation hearings 3 years earlier had been contentious but ultimately successful, and she had since authored several influential majority opinions that had reshaped American jurisprudence in ways that delighted conservatives and horrified liberals. Her navy blue suit was immaculately tailored, her auburn hair pulled back in her signature style, her expression conveying the kind of intellectual confidence that came from a lifetime of being the smartest person in most rooms. She had graduated summa cum laude from Notre Dame Law School, clerked for Justice Antonin Scalia, and spent years as a respected federal appellate judge before her elevation to the nation's highest court. Today's hearing, officially titled Judicial Ethics and Constitutional Interpretation in the Modern Era, was supposed to be a routine examination of the court's administrative procedures and ethical guidelines. Barrett had prepared extensively with her clerks and the court's media relations team, anticipating the usual range of questions about court operations, public confidence in the judiciary, and general judicial philosophy. She had reviewed her standard talking points about constitutional fidelity, judicial restraint, and the importance of interpreting legal texts according to their original public meaning. She had prepared measured responses to predictable questions about recent controversial decisions, carefully crafted to reveal nothing while appearing completely transparent. What she hadn't prepared for was the thick manila folder that Representative Jasmine Crockett had placed conspicuously on the committee table in front of her. Crockett, serving her second term in Congress and wielding the sharp analytical skills honed during her years as a prosecutor in Dallas, had spent the past month conducting what she privately called archaeological research into Barrett's prejudicial writings, law review articles, symposium papers, academic commentary, book reviews, conference presentations, all published years before Barrett's appointment to the federal bench, when she was simply Professor Barrett at Notre Dame Law School. The folder contained photocopies of articles that Barrett herself had likely forgotten she'd written, meticulously annotated with Crockett's careful notes in different colored pens. Highlighted passages in yellow marked particularly relevant quotes. Green, sticky notes indicated contradictions with Barrett's judicial opinions. Red flags marked the most damaging inconsistencies. Crockett had assembled this archive with the methodical precision that had made her a feared prosecutor. She had spent hours in law libraries, scoured legal databases, and even tracked down out-of-print symposium proceedings from academic conferences Barrett had attended in the 1990s and early 2000s. What had emerged from this research was a portrait of a brilliant legal mind grappling seriously with complex constitutional questions, a scholar who had written thoughtfully about the limitations of originalism, the importance of judicial humility, and the need for constitutional interpretation to serve democratic values, even when that required acknowledging complexity and uncertainty. It was a portrait that stood in stark contrast to the rigid ideologue who now sat on the Supreme Court. Committee Chairman Dick Durbin called the hearing to order at 10 a.m. sharp, his voice carrying the gravitas appropriate to the occasion. Justice Barrett, thank you for appearing before us today to discuss the vital work of the federal judiciary and the important questions facing our constitutional system. Barrett leaned into her microphone with practiced authority, her voice carrying the confident tone that had served her well through countless judicial confirmations and public appearances. Thank you, Chairman Durbin. I'm pleased to discuss the court's commitment to constitutional fidelity and judicial independence, and to address any concerns this committee might have about the court's work. The first hour proceeded predictably, following the familiar rhythms of congressional oversight hearings. Republican senators asked friendly questions about court efficiency and caseload management, lobbing softball inquiries that allowed Barrett to showcase her command of judicial administration. Democratic senators probed more gently on ethics issues and public perception, but within the bounds of typical political theater. Senator Chuck Grassley asked about the court's technology upgrades. Senator Lindsey Graham inquired about Barrett's perspective on judicial workload. Senator Amy Klobuchar raised questions about public confidence in the judiciary, but in the measured tones of someone who understood the political constraints of the moment. Barrett deflected each question with the skill of someone who had mastered the art of saying very little while appearing to be completely forthcoming. She spoke in careful, lawyerly language about the court's important work, the need for constitutional fidelity, and her deep respect for judicial precedent and the rule of law. It was the kind of performance that had made her a darling of conservative legal circles. Intellectually impressive but ideologically safe, substantive enough to demonstrate competence, but careful enough to avoid controversy. But at 11:15 a.m., when Chairman Durbin called on Representative Crockett for her questioning period, the atmosphere in the room shifted perceptibly. Something in Crockett's posture, the way she organized her materials, the focused intensity of her preparation, suggested that the routine portion of the hearing was about to end. Crockett opened her folder and pulled out a document, handling it with the careful precision of someone presenting evidence in a criminal trial. Justice Barrett, I'd like to begin by discussing your approach to constitutional interpretation, particularly as it relates to your scholarly work prior to joining the bench. Barrett nodded confidently, settling into what she expected to be a familiar discussion of judicial philosophy. Of course, Representative. I've always believed in interpreting the Constitution according to its original public meaning, as understood by those who ratified it. Excellent, Crockett said, consulting the document in her hand with the focused attention of a prosecutor reviewing key evidence. That's consistent with what you wrote in your 1998 Law Review article, Constitutional Originalism, Theory and Practice, published in the Notre Dame Law Review. I found that piece quite illuminating. Barrett felt a slight flutter of unease, the first crack in her composed facade. She hadn't thought about that particular article in years. It was buried deep in her academic past, written when she was still a young professor trying to make her mark in constitutional scholarship. In that article, Crockett continued, her voice taking on the measured cadence of someone building a case, you wrote that originalism provides the most democratically legitimate form of constitutional interpretation because it constrains judicial power within textual and historical boundaries. Is that still your view? Yes, Barrett replied, though something in Crockett's tone, the careful precision, the sense of a trap being set, suggested this wasn't going to be a straightforward endorsement of originalist theory. I'm glad to hear that, Crockett said, turning to another page in her folder with deliberate care. Because I want to examine how that theory has been applied in your judicial opinions, particularly in cases involving reproductive rights. Barrett's posture stiffened slightly, her hands gripping the edge of the witness table as she recognized that the conversation was moving into more dangerous territory. Representative, I believe my opinions speak for themselves. They certainly do, Crockett agreed, her voice remaining professionally neutral, but carrying an undertone that suggested Barrett's confidence might be misplaced. In fact, that's exactly what I want to discuss. In your recent opinion in Women's Health Alliance versus Department of Health and Human Services, You wrote that the Constitution contains no explicit right to reproductive autonomy, and therefore such rights cannot be constitutionally protected. Barrett nodded, falling back on the textualist arguments that had become second nature to her. That's correct. The text of the Constitution does not enumerate such a right, and I believe judges must be constrained by what the text actually says. Interesting, Crockett said, pulling out another document from her folder. This one flagged with several colored tabs. Because in your 1999 article, Implied Constitutional Rights and Democratic Governance, published in the Constitutional Commentary Journal, you took a rather different position. The justice felt her stomach tighten, a growing sense of unease as she realized that Crockett had done far more research than the typical congressional questioner. She had no clear memory of what she had written in that decades-old piece. But something about Crockett's confident handling of the materials suggested it wasn't going to be favorable to her current positions. In that article, Crockett continued, consulting her careful annotations, you argued that constitutional interpretation must account for the fact that the framers deliberately used broad language in certain provisions, particularly the 9th and 14th Amendments, to allow for the recognition of fundamental rights that cannot be explicitly enumerated. Barrett blinked, feeling the first wave of genuine alarm as her own words were read back to her. Representative, I'd need to review the specific context of that passage. Of course, Crockett said helpfully, her tone remaining scrupulously polite, while the content of her questions grew increasingly devastating. Let me provide the full context. You were discussing the constitutional basis for recognizing unenumerated rights, and you specifically wrote, and I quote, "The 14th Amendment's guarantee of liberty necessarily encompasses certain reproductive decisions that are fundamental to personal autonomy and human dignity." The silence in the committee room was deafening. Reporters leaned forward in their seats. Legal scholars in the gallery exchanged meaningful glances. Even the typically chatty Senate staffers fell quiet as the implications of what Crockett had just read sank in. Justice Barrett, Crockett continued, her voice remaining professionally neutral, but her questions growing more pointed. Can you help me understand how your scholarly position that reproductive autonomy is constitutionally protected evolved into your judicial position that it is not? Barrett felt trapped between her intellectual past and her political present, caught in a contradiction that had no easy resolution. She couldn't deny having written words that were being quoted directly from her own published work, but she also couldn't acknowledge the apparent contradiction without undermining either her current judicial philosophy or her intellectual consistency. Representative, academic writing allows for the exploration of various theoretical approaches. So you no longer believe that the 14th Amendment encompasses reproductive decisions? Crockett interrupted gently, not allowing Barrett to escape into academic abstractions. I believe the Constitution must be interpreted according to its original public meaning, Barrett replied, falling back on her standard formulation like a mantra that could ward off the growing sense that this hearing was spinning out of her control. I see, Crockett said, making a note on her pad with deliberate care. Let me ask about another area where your scholarly and judicial positions seem to diverge. In your recent opinion, in Corporate Political Action versus Federal Election Commission, you wrote that corporate political speech deserves robust First Amendment protection because corporations are associations of individuals exercising collective speech rights. Barrett nodded, grateful for what seemed like safer ground. That's an accurate characterization of my reasoning. Crockett turned to another document in her folder, this one heavily annotated with sticky notes and highlighter marks. But in your 2001 article, Corporate Personhood and Constitutional Theory, published in the Harvard Law Review, you argued that extending full constitutional rights to corporate entities fundamentally distorts the individual-centered framework of constitutional protection and undermines the democratic principle that political speech should flow from actual citizens rather than artificial legal entities. Barrett looked like she wanted to disappear into her chair, the color draining from her face as another contradiction was laid bare. Representative, that article was exploring theoretical frameworks. You also wrote, Crockett continued reading, her voice steady and prosecutorial. The fiction of corporate personhood becomes constitutionally problematic when it allows concentrated economic power to masquerade as democratic political participation. She looked up at Barrett with the focused attention of a cross-examiner who had caught a witness in a crucial inconsistency. Justice Barrett, that sounds like a pretty definitive position on corporate speech rights. What changed your mind? Barrett struggled for a response that could reconcile the irreconcilable. Academic exploration of constitutional theory involves examining multiple perspectives. Multiple perspectives, Crockett repeated, allowing the phrase to hang in the air like an accusation. So your current judicial opinions don't necessarily reflect your most thoughtful analysis of constitutional questions. They reflect one perspective among many that you've considered. The question was devastatingly precise, designed with the skill of someone who had spent years constructing logical traps for witnesses. If Barrett said yes, she would be admitting that her judicial opinions were arbitrary, chosen from a menu of equally valid options based on non-legal criteria. If she said no, she would be admitting that she had abandoned her earlier, more thoroughly reasoned positions in favor of ideological convenience. Representative, judicial decision. Making involves applying constitutional principles to specific factual circumstances. Let me ask about one more area, Crockett said, not allowing Barrett to finish her non-answer and escape into procedural abstractions. Voting rights. In your recent opinion in State Electoral Integrity versus Voting Rights Alliance, you upheld state restrictions on voting access, writing that the Constitution provides only minimal protection for voting rights, and that states have broad authority to regulate electoral processes. Barrett nodded warily, sensing that another trap was being set, but unable to see its exact contours. But in your 2003 article, Democratic Participation and Constitutional Protection, published in the Yale Law Journal, you wrote that voting rights represent the foundational element of democratic legitimacy, and constitutional interpretation must err on the side of protecting rather than restricting access to the franchise. Crockett flipped to another page, her movements precise and deliberate. You also wrote that state regulations that disproportionately burden voting access undermine the constitutional commitment to democratic equality and should be subject to the highest level of judicial scrutiny. She looked directly at Barrett, her gaze unwavering. Justice Barrett, the opinion you authored upheld voting restrictions without applying heightened scrutiny. How do you reconcile that with your scholarly position that such restrictions should face the highest level of constitutional review? Barrett was now visibly uncomfortable, shifting in her chair and repeatedly reaching for her water glass as if trying to buy time to formulate a response that could somehow explain away the contradictions. Representative, the evolution of constitutional jurisprudence. Evolution, Crockett interrupted, seizing on the word like a prosecutor who had finally gotten the admission she was looking for. Justice Barrett, in your confirmation hearings, you testified under oath that your judicial philosophy was grounded in consistent principles of originalism and textual interpretation. But what I'm seeing in your scholarly work is a thoughtful, nuanced approach to constitutional interpretation that recognizes complexity and ambiguity. She gestured to her folder, now revealed to be a comprehensive archive of Barrett's intellectual development. Your academic writing shows deep engagement with constitutional theory, careful consideration of competing values, and recognition that the Constitution must adapt to serve democratic principles in changing circumstances. Crockett's voice grew stronger, taking on the rhetorical power that had made her a formidable prosecutor. But your judicial opinions show none of that nuance. They show a rigid, selective application of originalism that consistently produces conservative political outcomes, regardless of the constitutional text or historical evidence. Barrett tried to respond, but Crockett wasn't finished building her case. Justice Barrett, based on your own scholarly work, you clearly understand that constitutional interpretation is complex, that originalism has serious limitations, and that rigid adherence to any single interpretive methodology can produce unjust results. She leaned forward, her voice taking on the intensity of a closing argument. So my question is simple. Are you a worse constitutional scholar now than you were 20 years ago? Or are you allowing political considerations to override your legal judgment? The question hit the committee room like a thunderclap. Several senators visibly reacted, leaning forward in their chairs. Reporters frantically typed notes, recognizing that they were witnessing something extraordinary. Barrett looked stunned, her usual composure completely shattered. Representative, I believe my judicial opinions reflect careful constitutional analysis. Based on what? Crockett asked, her voice sharp and unforgiving. Because your own scholarly work suggests that careful constitutional analysis would reach different conclusions in virtually every major case you've decided. She pulled out one final document, this one marked with a red tab indicating its particular importance. Justice Barrett, I want to read you something you wrote in 2004 in an article called Judicial Humility and Constitutional Interpretation, published in the Minnesota Law Review. You wrote, "Judges who claim certainty about constitutional meaning are either intellectually dishonest or dangerously naive. Constitutional interpretation requires intellectual humility, recognition of complexity, and acknowledgement that reasonable people can disagree about fundamental constitutional questions." Crockett looked up from the paper, her gaze boring into Barrett with the intensity of someone delivering a final, fatal blow. Justice Barrett, when I read your recent opinions, I don't see intellectual humility. I see someone who has abandoned the thoughtful, careful approach to constitutional interpretation that you once advocated in favor of reaching predetermined political outcomes. The silence that followed was profound and uncomfortable, stretching for long seconds, as Barrett struggled to formulate any response that could address the systematic demolition of her intellectual consistency. Barrett's voice was shaky when she finally responded, her usual confidence completely evaporated. Representative, I believe my judicial philosophy has remained consistent. With all due respect, Justice Barrett, your own words prove otherwise, Crockett said, her voice carrying the finality of a prosecutor delivering a closing argument. The question facing this committee and the American people is whether the Supreme Court is being led by thoughtful constitutional scholars or by political operatives in judicial robes. She began gathering her papers with deliberate ceremony. Based on the contrast between your scholarly work and your judicial opinions, I'm afraid I know the answer to that question. Crockett paused, looking directly at Barrett one final time. Justice Barrett, you once wrote that constitutional interpretation requires intellectual honesty and the courage to acknowledge uncertainty. But your judicial career suggests that you've traded intellectual honesty for ideological consistency and courage for political convenience. Her voice took on a tone of profound disappointment. The scholar who wrote those thoughtful articles about constitutional complexity and judicial humility might have made a great Supreme Court justice. Unfortunately, that scholar appears to have been replaced by someone more interested in political outcomes than legal reasoning. As Crockett's time expired and the hearing moved to the next questioner, Barrett sat in stunned silence, looking smaller and more vulnerable than anyone had ever seen her. The careful academic work of her younger self had been weaponized against the political ideology of her current position, and there was no intellectually honest way to reconcile the contradiction. The remaining senators seemed almost anticlimactic after Crockett's systematic deconstruction. Barrett answered their questions mechanically, her usual sharp intellect clearly rattled by what had just occurred. When the hearing finally adjourned at 3:30 p.m., Barrett left through a side exit, avoiding the press gaggle that had gathered in the hallway. She looked exhausted and defeated, a stark contrast to the confident jurist who had entered the building that morning. Within hours, legal scholars across the country were downloading Barrett's old law review articles, comparing them to her judicial opinions, and reaching uncomfortable conclusions about the intellectual consistency of one of the court's most influential members. Professor Lawrence Tribe of Harvard Law School tweeted, "Reading Barrett's early scholarship alongside her recent opinions is like comparing a thoughtful constitutional theorist with a political hack. The transformation is both remarkable and deeply troubling." Conservative legal scholar Stephen Calabresi, who had supported Barrett's nomination, published a blog post titled "The Curious Case of Justice Barrett's Evolving Constitutional Theory," in which he wrote, "While judicial philosophy can certainly develop over time, what Representative Crockett documented appears to be not evolution, but wholesale abandonment of previously held principles." The Liberal Constitutional Accountability Project issued a statement calling for Barrett's recusal from cases involving issues on which her scholarly and judicial positions contradicted each other, arguing that her intellectual inconsistency raises serious questions about whether her decisions are based on legal reasoning or political calculation. But perhaps the most telling response came from Barrett herself. 3 weeks after the hearing, she quietly withdrew from a scheduled appearance at a constitutional law symposium at her alma mater, Notre Dame, citing scheduling conflicts. 2 months later, she cancelled a planned lecture series at the University of Virginia Law School that was to have been titled "Originalism and Constitutional Interpretation." The Supreme Court's press office began declining interview requests for Barrett, and her public speaking engagements dropped to nearly zero. The justice, who had once been a sought-after speaker at legal conferences and conservative events, seemed to have retreated from public view, clearly stung by the exposure of her intellectual contradictions. Legal clerks at the court reported that Barrett had become notably more defensive about her opinions, spending considerably more time trying to reconcile her current positions with her academic past. Some observed that her recent majority opinions had become longer and more defensive, as if she were trying to convince herself as much as her audience. The hearing's impact extended beyond Barrett herself. Several pending Supreme Court cases involving reproductive rights, corporate speech, and voting access were suddenly seen in a new light, with legal observers questioning whether Barrett's positions were based on consistent constitutional principles or political convenience. The Crockett hearing, as it came to be known, became required viewing in constitutional law classes across the country, used as an example of how to hold powerful figures accountable to their own stated principles. Law professors assigned students to compare Barrett's scholarly writings with her judicial opinions, leading to a new generation of legal scholars more skeptical of claims of principled constitutional interpretation. 6 months after the hearing, a poll by the American Bar Association found that public confidence in Barrett's judicial integrity had dropped by 23 points, with even 31% of Republican lawyers expressing concern about the contradictions between her scholarship and her jurisprudence. The hearing also elevated Crockett's profile significantly. Legal scholars praised her methodical approach to accountability, and she was invited to speak at law schools across the country about the importance of intellectual consistency in constitutional interpretation. Representative Crockett demonstrated something crucial, wrote Yale law professor Akila Ma. The most effective accountability doesn't require new evidence or complex legal theories. It requires the simple courage to hold people accountable to their own previously stated principles. A year later, when Barrett authored a controversial majority opinion striking down federal environmental protections, Crockett issued a statement that simply quoted from Barrett's 1997 Law Review article, arguing that constitutional interpretation must account for evolving scientific understanding and democratic values. The statement included no commentary. The contradiction spoke for itself. Because sometimes the most devastating critiques come not from political opponents, but from the words we wrote when we still believed that ideas mattered more than outcomes. The Crockett-Barrett hearing became a turning point in how congressional oversight could hold judicial figures accountable, proving that the most powerful tool in democracy isn't authority or ideology. It's the courage to hold people accountable to their own stated principles, documented in their own words, published under their own names. If this story reminded you that intellectual honesty matters more than political loyalty, and that our past words can be our present accountability, Make sure to subscribe for more stories of people who prove that the most powerful weapon against hypocrisy is simply reading someone's own words back to them.